So another 30 days yourself! Great!
First up, let's take a seat at Hillsborough Circuit Court, where Judge Christopher Sabella is about to sentence Amber Pereira. 31-year-old Pereira was in court after she was convicted of being at the wheel during a fiery crash along the Selman Expressway in 2017. Amber Pereira, who was intoxicated, caused a chain reaction wreck that killed 3 members of the Phillips family. Brace yourself as we delve into the details of this crime, the trial that followed, and most importantly, Pereira's reaction to her sentence. It was a quiet evening on the Selman Expressway, a stretch of road that connected the bustling city of Tampa, Florida. Little did anyone know that this seemingly ordinary night would soon turn into a nightmare. The stage was set for a tragedy that would send shockwaves through the community. Amber Pereira, a 31-year-old woman, was behind the wheel that fateful night. She weaved in and out of traffic, showing no regard for the safety of others on the road. Her entitled mindset led her to believe that the rules didn't apply to her and that she could do as she pleased without facing any consequences. Meanwhile, a loving family was enjoying a peaceful drive, completely unaware of the danger that lurked just a few lanes away. Louise, Rita, and their 8-year-old daughter, Georgia Phillips, were on their way home, their laughter filling the car as they shared precious moments together. In a horrifying twist of fate, Amber's reckless driving led to a devastating collision. The sound of screeching tires and shattering glass filled the air as the Phillips Hyundai struck a Jeep in an Infiniti before bursting into flames. All 3 of the Phillips died on the spot, and the Jeep's driver, Tracy Lee Kelly, was seriously injured. As the dust settled, Amber had a choice to make. She could have stayed at the scene, faced the consequences of her actions, and offered whatever help she could. But instead, she made a callous decision that would forever define her character. Amber callously drove away from the wreckage, leaving behind a trail of destruction and shattered lives. Her selfishness and lack of empathy were on full display as she chose to avoid any responsibility for the devastation she had caused. The news of the tragedy spread like wildfire, leaving the community in a state of shock and mourning. The loss of this loving family sent ripples of grief through the hearts of those who knew them and even those who didn't. The impact of Amber's actions was felt far and wide. The Selman Expressway, once a symbol of convenience and connectivity, now stood as a haunting reminder of the lives lost and the pain inflicted by one woman's reckless choices. The community demanded justice, and they would soon get their day in court. The trial of Amber Pereira was a highly anticipated event that gripped the nation. The courtroom buzzed with tension as the prosecution and defense prepared to present their cases. All eyes were on Amber, the woman whose reckless actions had shattered the lives of an innocent family. The prosecution wasted no time in painting a vivid picture of Amber's actions on that fateful night. They argued that Amber's reckless driving, her complete disregard for the safety of others, and her decision to flee the scene were clear indicators of her guilt. They painted her as a woman consumed by entitlement, someone who believed she could escape the consequences of her actions. The weight of the tragedy was too great to be dismissed as a mere accident. After days of intense deliberation, the moment of truth arrived. The judge, with a stern expression, delivered the verdict that would determine Amber's fate. Amber Pereira was found guilty of the charges brought against her. The weight of her actions finally caught up with her, as she was sentenced to 50 years in prison. As soon as she heard the judge's verdict, Amber placed her head on the desk and began to sob uncontrollably. Her reaction quickly went viral, capturing the attention of the nation.
I understand that this courthouse is a cursed courthouse. Yes, I understand. And if you are judging me, you're not God-fearing, Allah will have his vengeance on you, and everyone else in here is not God-fearing.
Next, we're at the Douglas County Superior Court, where a judge presides over the chilling case of Sahara Fakir, charged with armed robbery, burglary, and murder. Fakir's case captivated the nation as she made outrageous claims and invoked divine intervention in the courtroom. As the hearing begins in Douglas County, Georgia, all eyes are on the defendant, Sahara Fakir. At 32 years old, Fakir stands accused of committing a series of heinous crimes, including armed robbery, burglary, and murder. The victim, Jerry Wheeler, a respected local businessman, was brutally stabbed in his own home while innocently preparing dinner. To make matters even more tragic, Wheeler was the father of a dedicated deputy deputy from the Douglas County Sheriff's Office who discovered his lifeless body. As Fakir enters the courtroom, it becomes evident that she fails to grasp the gravity of the charges against her. With an air of nonchalance, she appears seemingly unaffected by the weight of the situation. The judge presiding over the case, known for his composed demeanor, takes Fakir's claim in stride and proceeds with the proceedings.
You're charged with the murder of Jerry Franklin Wheeler. You understand that?
In the Masonic courthouse, I understand that. I understand that this courthouse is a cursed courthouse. Yes, I understand.
Okay.
And if you are judging me and you're not God-fearing, Allah will have his vengeance on you, and everyone else in here is not God-fearing. I understand that.
However, as the topic shifts to legal representation, Fakir's behavior takes a bizarre turn. The judge, seeking to ensure that Fakir has proper legal counsel, asks her if she has a lawyer, and she gives a shocking response.
Do you have a lawyer?
Allah is my lawyer right now.
Are you
He's speaking for me.
Are you going to get a lawyer?
Allah is my lawyer right now. And if you do not release me, Allah will have his vengeance on you. Like he did in 2009 when he sent that flood. It's only going to get worse.
Her claim leaves the courtroom in stunned silence. Recognizing that Fakir may not have the means to employ a lawyer, the judge informs her of her right to apply for a public defender at no cost. However, Fakir remains steadfast in her conviction that Allah is her ultimate advocate. She demands to be released from the Masonic courthouse, further showcasing her unconventional beliefs and refusal to conform to the legal process.
If you cannot employ a lawyer, then you can apply to the public defender's office for an appointment of one at no cost to you.
I mean what I said.
I'm just trying to inform you of your rights.
No, I better be released from that Masonic courthouse.
As the hearing nears its end, Fakir's hopes of being granted bond are dashed. The judge firmly states the bond will not be granted that day, prompting Fakir to question the decision.
Bond will not be granted today. If you want such a bond, you can make application and have a hearing as to that matter. Do you understand?
Why can't I get a bond today?
I'm not going to grant a bond today. This is just an initial appearance.
Why?
Because it's going to have a hearing to have a bond.
She then goes ahead to take a dig at the news channel covering the hearing. Fakir's case eventually went to trial, and she was sentenced to life in prison without parole for the murder of Jerry Wheeler.
A mother will spend the rest of her life in prison for murdering her 6-year-old son.
I'm innocent. You all, you're garbage.
Next, we're at Hennepin County District Court, where Judge Jay Quam presides over the case of 29-year-old Jalissa Taylor, whose anger and defiance have taken center stage as she reacts to her life sentence for the murder of her 6-year-old son, Eli Hart. Brace yourself as we delve into the chilling details of this crime and also find out what the judge's verdict would be. May 2022 marked the beginning of a tragic tale that would ultimately lead to the life sentence of Jalissa Taylor, a mother-turned-murderer. Taylor, a seemingly ordinary woman, resided in this quiet suburban neighborhood with her 6-year-old son, Eli Hart. But behind closed doors, a dark secret was brewing, one that would shatter the lives of those involved. It was on a fateful day in May when a concerned citizen made a chilling discovery. A shattered rear window and a blown-out tire caught their attention, prompting them to make a call that would change everything. The authorities swiftly responded to the call, arriving at the scene to investigate the suspicious car. Little did they know the unimaginable horror that awaited them. As investigators cautiously opened the trunk, their worst fears were realized. The lifeless body of 6-year-old Eli lay before them, a victim of unspeakable violence. The discovery sent shockwaves through the community, and the search for answers began. Jalissa Taylor, the mother who was supposed to protect and care for her son, now faced the weight of the evidence against her. The trial that followed was a harrowing journey into the depths of a mother's betrayal. The prosecution presented a compelling case, meticulously piecing together the events that led to Eli's tragic demise. It was revealed that Eli's murder was as shocking as it was preventable. Only 10 days earlier, Dakota County had closed a child protection case against Taylor, one in which records show she repeatedly lied to caseworkers, filed false court claims, failed drug tests, committed crimes, and even stalked the boy's foster parents. The revelations come from hundreds of pages of emails between child protection workers, caseworker notes, police reports, and court transcripts. The court also learned that for his safety, Eli had been removed from his mother's care in January 2021 after she had a series of mental health breakdowns. Despite a wave of warning flags, officials returned Eli to his mother just 11 months later for what's known as a trial home visit. Even when the child's father, Torrey Hart, made several complaints about Taylor, who had a long history of drug abuse, paranoia, and other mental health issues. As well as having the police down her place 21 times over 10 months, she was still granted full custody of Eli. Not long after, the body of the young child would be discovered in her trunk. He had been shot 9 times. The courtroom was filled with tension as the prosecution presented evidence of Jalissa Taylor's guilt. Witnesses testified, painting a grim picture of a mother who had lost her way.
No one should ever have to feel this kind of pain or experience this kind of trauma. But we have been sentenced to a lifetime of this pain, confusion, grief, sorrow, and trauma. A lifetime without Eli.
And then came the moment when Jalissa Taylor was given the opportunity to address the court. Her outburst shocked everyone present as she vehemently proclaimed her innocence and directed profanity towards the court and those in attendance.
Ms. Scholar, you have a right to speak this morning if you'd like. You don't have any obligation to speak, but if you'd like to choose to speak, now is the time to do it.
Yes, I would like to say something.
Go ahead.
I'm innocent. You all, you're garbage.
Despite her claims of innocence, the evidence against Jalissa Taylor was overwhelming. And on that fateful day, a Hennepin County judge delivered the final verdict.
Nothing I do would bring justice to this situation. Nothing I do would relieve any of the pain that you caused by doing that. But what is, according to law, the just and fair sentence for what you did is what Mr. Allard said, and that is life in prison without the possibility of parole.
Jalissa Taylor would spend the rest of her life in prison without the possibility of parole. As the courtroom was being evacuated, Jalissa Taylor, who was the very picture of unremorse, was seen showing a middle finger to the camera. Next, we go to San Antonio, Texas for a plea hearing. 32-year-old April Zuniga has been charged with burglary of a habitation, which is a felony. 4 months earlier, according to police reports, Zuniga and her boyfriend allegedly entered a neighbor's home and stole a PlayStation console and other items. The incident was captured by a doorbell camera. Zuniga, a mother of 3, was already on probation for DWI. This most recent offense is a violation of that probation. Today, she's in court to plead guilty in the hope of avoiding jail time. The presiding judge is Stephanie Boyd.
State of Texas versus April Zuniga. And are you Ms. Zuniga?
Yes, ma'am.
Zuniga is appearing remotely, but seems to be having some technical issues. The judge continues with the hearing, asking prosecutor Brittany Sparks to list the new charge.
The defendant, April Zuniga, committed the offense of burglary of a habitation in violation of condition number 1.
How do you plead to that, true or not true?
True.
By pleading guilty to violating her probation, Zuniga now faces a possible sentence of up to 6 years. But the state is recommending continued probation. Judge Boyd agrees and moves on to the burglary charge.
Next, we're going to proceed in clause number 2022, CR 3449W. Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case that you review it with your file?
Yes, Your Honor, I did.
Ms. Zuniga?
It sounds like the defendant has become preoccupied with other business.
Ms. Zuniga?
Yes, ma'am.
Are you not able to find a place other than a commercial restroom?
Okay, I just came out of there. Sorry. Because I was right here at my son's school for the pickup.
So no, is there some other place other than a restroom? We don't want to hear toilets flush.
Oh, no. I already came out of there. It's just because I was in my son's school, picking them up. So I'm not in the restroom.
So did you just leave the restroom?
Yes, ma'am.
All right.
The judge returns to the business at hand, but background noise is still an issue.
Did you review the document entitled Information with your attorney? Did you understand it?
Yes, I did. It's just, it was because, yes.
Okay,
yes,
Ms. Zuniga?
Yes, ma'am.
Are you still at school?
Do you want me to step out the school?
Yes, please.
Okay. Okay, I'm out the school.
All right.
Now Zuniga just has to officially enter her plea for the burglary charge.
Dan, how do you plead? Guilty, not guilty, or no contest?
No contest.
All right, after reviewing, see, Ms. Zuniga, you are not out of the restroom. You are still in the restroom.
I know. I had to come back inside.
In total, Zuniga was sentenced to 4 years probation plus drug and alcohol testing, and she must serve 120 hours of community service. Next, we head to Jefferson County Courthouse in Kentucky for a case that shows just how emotionally difficult it can be for a prosecutor working on a horrific crime.
Okay, good morning. We're on the record. This is the matter of the Commonwealth versus Molly Schaus.
This is the arraignment of Molly Schaus.
Ms. Schaus, you have a charge of murder, second-degree possession of a controlled substance, and possession of marijuana.
Schaus has been charged with murder after allegedly leaving her 2-year-old son to die in a hot car while she was passed out inside her home, high on Xanax and marijuana. The tragic year-long case is wrought with emotion. At times, Schaus broke down in tears during the trial, causing delays in the proceedings.
There's no doubt in my mind that your emotions are genuine. Nonetheless, it is necessary for us to get through this trial without interruption.
Eventually, the trial was completed, and it took just 2 hours for the jury to find Schaus guilty of murder. But before Judge Olu Stevens delivered final sentencing, the emotional burden of the victim impact statement fell on the shoulders of prosecutor Aaron McKenzie.
Kenton Brown cannot give you a victim impact statement. And there is nobody here in this courtroom from his family to give you a victim impact statement. The little boy that sat in his car seat and suffered for hours upon hours while his skin seared against the hot plastic of the buckle between his legs, with his little wet diaper stuck to him in the heat. There's nobody here to speak for Kenton today. So I don't just speak on behalf of this community, Your Honor. I speak for the victim. I speak for the life that was lost.
Now Judge Stevens will have to determine her sentence.
Ms. Schaus, you chose the drugs over the life of your child. And so the court will sentence you today.
Judge Stevens agrees with the jury's recommended sentence of 35 years in prison.
In accordance with the jury verdict, murder will be 28 years. Possession of controlled substance first, 3 years. Criminal abuse, 2 years. Wanton endangerment first, 2 years. Each will run consecutive to the other. The total sentence is 35 years.
But the story didn't end there. In a stunning turn of events, Schaus's conviction and sentence were thrown out by the Kentucky Supreme Court. The High Court found the prosecutors were not allowed under state law to prosecute Schaus on a particular type of murder. In 2000, state lawmakers created a new type of second-degree manslaughter to apply when young children die after being left in vehicles. As a result, Schaus pled guilty to that lesser charge. Instead of serving the maximum 35-year sentence she was initially given, Schaus was released after serving just 3. Next, we're in Traverse City, Michigan for a bond violation hearing. 44-year-old Shannon Hui has pled guilty to the crime of attempted unlawful driving of an automobile, while a second similar charge from the same incident was dismissed. She was sentenced to 2 years probation with several conditions, including drug and alcohol testing. But after Hui allegedly violated her probation, she was arrested again and then released on a personal bond. And when she failed to appear at her sentencing, she was arrested a third time. Today, she appears without an attorney before Judge Michael Stepka to discuss next steps in the case.
You were before the magistrate earlier this afternoon on
Yes.
video. You had the defense counsel with you. You told both of those people you wanted to waive a hearing, waive a lawyer, and plead guilty to bond violation. Is that right, ma'am?
Yeah, I guess whatever I need to do to get this done.
So we have to reset sentencing.
Why can't we do it today? Can't you sentence me right now?
Your lawyer isn't in there, so we can't sentence you.
Can I do not guilty, please? Can I have a bond, please?
So I think you should call Janet Mistley. She's your lawyer. We're going to reset your sentencing that you missed on March 16th.
I'm not going to call her. Just sentence me. Just get this over with. Sentence me. Like, this is not who I am, and I just want this done. I want to move on.
So what we're going to do is enter a not guilty plea on the bond violation. The bond violation will be set at the same time as sentencing. I think we might be able to give you the date now.
That will be April 12th at 10 a.m.
So I've got to sit in jail until April 12th? I'm sorry.
Well, yes.
Hang on,
because you failed.
I'm having a hard time hearing.
Yes, you failed. You failed to
So another 30 days yourself! Hey!
You failed to show.
So another 30 days yourself!
Huey suddenly loses it and smashes the computer. Officers quickly entered the room and subdued the defendant.
Why are you touching me like that? Ah! I cut myself. Wait, I cut myself. Ah!
It seems Huey has cut her hands on her cuffs during the outburst.
I'm not fighting you.
Put your other arm behind your back.
I just want to be sentenced and want to be done with this. I'm so over you people. I'm bleeding.
Take a deep breath. Let's get her out of this room.
Watch your step.
After several minutes, the officers remove Huey from the room and take her into custody. While she was not charged for the outburst, Huey eventually pled guilty to violating her probation, and her bond was revoked. She was later sentenced to 180 days in jail, credit for time served. Next, we're in Ann Arbor, Michigan for a post-sentencing hearing. 37-year-old Shannon Phillips has not been making payments on the court-ordered restitution and court fees that were part of her sentence. 5.5 years earlier, Phillips got into a physical altercation with store owner Tyrone Curry about how much change he owed her from a lottery ticket purchase. Tyrone told police that Phillips went behind the counter and threw merchandise around the store. He also told them she had a gun in her pants and had threatened to shoot up the store. Phillips was arrested and charged with carrying a concealed weapon and malicious destruction of property. During a bench trial, she was found guilty of both charges by a judge. She was sentenced to 6 months in jail, followed by 3 years probation. She was also ordered to pay $4,300 in restitution to Tyrone for the damaged property. Phillips made regular payments for 3 years, but has fallen behind in the last year. She's paid less than half the amount she owes to the victim. Today, Phillips is before Judge Patrick Conlon to address the outstanding payments.
Let's see if we can resolve this. Is Shannon Phillips or anyone representing her in court today? Ms. Phillips, are you there? Are you Shannon Phillips, who's identified as UCC 1-308, all rights reserved?
This is Shannon Phillips. She's chosen to log into the hearing as UCC 1-308, all rights reserved, and is not answering when the judge calls her name.
Okay, well, there's no response to the court's inquiry. It's 4:30 p.m. on July 13th.
We hear you now. Are you Ms. Phillips?
UCC 1-308, all rights reserved. I am here on special visitation of the all caps name.
While Phillips has not identified herself as such, she appears to be employing tactics and reciting language from the playbook of sovereign citizens, many of whom believe that adding certain codes and all rights reserved to their names will protect them from prosecution.
Okay. Seeing no response to my request, it's 4:30 p.m. The matter was scheduled for 1:30 p.m. Agent Miller, I will sign a bench warrant upon your submission. Failure to appear.
The judge is refusing to acknowledge Phillips until she identifies herself by her legal name.
My name is capital S, lowercase h, lowercase a, lowercase n, lowercase n, lowercase o, lowercase n.
Okay. Are you Shannon Phillips?
I am Shannon.
Judge Conlon is done playing the name game, so he wraps things up.
Okay. I'll sign the bench warrant when you issue it, Agent Miller. Feel free to send that up to my office.
I asked for it to be dismissed with prejudice. How y'all gonna sign the bench warrant and I'm sitting right here? I told y'all what my name was.
Phillips may be present, but the judge takes her refusal to properly identify herself as a failure to appear. Phillips continues talking as the court moves on to the next case.
Number 56, People versus Tyree Pitts, 21535 FH.
They mad.
I'm trying to assistant prosecutor on behalf of the people.
I do not consent.
Riverside.
I do not consent.
And you have no contact with his.
Phillips dropped out of the hearing, and a bench warrant was issued for her 9 days later. It remains outstanding. Her non-payment hearing has been rescheduled. Next, we're in Williamsburg, Kentucky for a bond revocation hearing. The defendant walking up to the podium is 42-year-old Shannon Fox Hamlin. Today, she's in court for allegedly violating conditions of her probation. Once at the microphone, she lets Judge Paul Winchester know she's being represented by a well-known name, maybe best known for his pro bono work.
And who's representing you today?
I'm represented by Jesus Christ.
That's right. Now a savior he may be. But one thing he not is a licensed member of the Kentucky State Bar. So the judge offers up the services of the public defender's office instead.
All right, so I'm going to appoint Mr. Findale
No,
to represent
I
you
don't want
today.
Mr. Findale. I have that right, Your Honor. And Jesus is going to represent through me. I do not want legal counsel.
Okay, all right, so what do you want to say?
I want to say that I have lived hard, loved hard, played hard, but I've been saved and applied the blood. I'm pardoned through Jesus Christ, okay? I have stumbled and I have failed many times, and mercy's rained from that bench. Not because I deserved it, but because I'm sure somebody prayed. Okay, I wanted to taste salvation and play over here too. I was riding the fence between me and you. God gave me a choice, and it's life or death. I kid you not. Do I look like the person that stood before you in August? Do I? I'm humble. I'm in a walk of shame.
But alas, Judge Winchester has had enough of the courtroom sermon.
Okay, let me ask you a question.
Yes.
Allegation is you failed to report to probation and parole.
Okay, sir. I have nothing in this world.
All I need is an answer.
No.
Did you go? Okay.
I went to probation, yes I did. But the next 2 times I didn't have no right.
In addition to not reporting to her probation officer as scheduled, Fox Hamlin has another violation.
On December the 9th, 2016, you were given a drug test and you were positive for methamphetamine, and that was confirmed by a lab.
Saved by the blood.
Okay, yes or no? Do you acknowledge that?
I acknowledge I'm saved by the blood.
Saved by the blood or exposed by the blood test?
I don't use drugs, Your Honor. I do not use it.
You've already told me that, but back on December of 2016.
His paper says so, but I will not admit it. He said I could...
Are you denying the allegations in this motion?
Yes.
Fox Hamlin's probation officer is then called on to offer testimony.
Back in December, did she test positive for drug use? She didn't.
He's not telling the whole truth, Your Honor.
Okay.
You expect me to, he needs to too.
All right, let me tell you something now. You can ask him a question.
Okay, have I
Can't
not
preach
been
to
in
him.
contact? When you called me and said the drug test came back methamphetamine, tell the truth, Shannon, what did I say?
I did not call you.
Brian Diggs, you are a liar in the court of Williamsburg. I promise you, Jesus is watching.
Okay, let me tell you something. I have to go by what the test
He
says.
is lying,
And
sir.
The
His
test
his
says.
test wasn't right.
What I'm telling you is, I have to go by what the lab says.
Can I make
Doesn't have anything to do with what he said.
Between me and you,
Okay.
prison is to reform me, right? To make me a good person for
Well,
society. Is
that
that
and to
correct?
keep you from breaking the law.
Okay. Well, do you believe that the blood applied by Jesus Christ can do more reform for me than Pee Wee Valley? Do you believe it can happen in 1 day, 1 minute, or 1 hour?
Well-
Sir, I'm sentenced to death. I'm going to die.
But as the defendant continues to argue, the judge asks the bailiff to escort her out and revokes her bond.
Mr. Engel, can you take her for me, please? Motion is sustained.
Sir, I have the right to speak, okay?
And you have the
my
right to
wife is
speak.
I'm going to speak, please. No, I'm going to speak to
now.
this judge. No, I'm going to speak to you right now. My wife is at stake. I'll die in prison.
Come on,
I have a right to. I won't go. You'll shoot me.
As it becomes more apparent that she is not going quietly,
If you stand out and have I won't go, sir. No, I won't go.
another court official enters to help remove her.
No, I won't go. You understand? I won't. No. Mr. Winchester, I won't go. No. I won't go. You understand? Don't shoot me before I go. I won't go.
You need to go. You don't
No,
want
I'm
to do
not.
that to you, okay?
You understand? I won't.
You need to go.
You see truth and you're denying it. No. Mr. Winchester, please. I want my family back. I've changed. No, they take me Jesus like he said, how you gonna look out?
As the struggle spills into the hallway, Fox Hamlin continues to resist, reportedly kicking one of the bailiffs and causing an injury to his hand. On top of having her bond revoked, Shannon Fox Hamlin was charged with contempt of court, second-degree assault, resisting arrest, and second-degree disorderly conduct. She was sentenced to 8 years in a Kentucky prison.
Now I have to stay where I'm at. I feel like I'm trapped in this life.
And Miss Ellison, I feel like you came here to waste my time.
This Karen is the greediest ex-wife in support court history. Words can't even begin to describe how baffled I am watching this. We've seen a fair share of entitled moms and insane people over on divorce court. One of my favorite shows, by the way, but today we're going to be witnessing what I think is the final boss when it comes to the entitled, greedy leech species that have stepped foot inside a courtroom. So, for a little quick context, this is an ex-wife who has been divorced for 2 years now and has received more than enough support following her divorce, as we're about to hear. But today she is back in the courtroom requesting even more money, which is a bit of a trend with these days, but it backfires pretty hard, as we're about to see.
You brought this case before the court. What's going on?
Well, I'm divorced from the person that didn't show up.
I see that.
Yes, and I'm here to ask the court for more spousal support. I went part-time on my job. I'm no longer working full-time. I've lost money, and the man's done nothing but cause me trouble since we've been divorced. He does all kinds of crazy stuff.
Okay.
And I deserve more money with all this harassment, plus I want a restraining order against him. This has to stop. My nerves are on edge. Can't take much more of it. But I think $100 a week extra for spousal support would be fair with all the, the headaches he's given me and everything like that.
You think it'll be fair?
Yes, I've left him alone. I don't go around him. It's him doing the harassing.
Okay. How long ago did you all get divorced?
It's been almost 2 years now.
Okay.
He just won't let go.
What is he doing to harass you?
Like 3 or 4 o'clock in the morning, he drives around the house blowing his horn at all hours of the morning.
Have you ever tried to call the police on him?
Well, by the time they get there, he's gone.
Okay.
Yeah, they've never caught him actually doing anything.
Okay.
He knows not to get caught, but I need a restraining order. That's the only thing that's really going to, I think, keep him away from me.
Okay.
And he found
well,
out
I don't do restraining orders in this court. You can go to another court and definitely request a restraining order. And I believe that's something you can do at your local police department too.
Okay, well, thank you. I didn't know that.
Yes, ma'am. That is definitely that. Now, I can, if you qualify, obviously, for an increase in spousal maintenance, that is something that I can entertain. So let's talk about that. You said you believe $100, an extra $100 a week is fair.
Yes.
Why do you believe that's fair?
Well, like I said, my wages have went down. I'm only working part-time now. We're doing layoffs and things like that, so...
you said your wages?
Yeah, my wages.
Okay.
Are going down, and his are going up because he still gets those 2 raises every year. He's been with that company forever. And he makes good money. I don't make half of what he's making. And it's been really tough.
Yeah, but you've been divorced for 2 years now. That's not your husband anymore. Why the hell would it make sense for him to start giving you more money just because you started making less income? That is completely on you there. Not gonna lie, I'm a little confused as to how this woman thought this would be a convincing case. So much so that she decided to actually bring it into the courtroom, and we're talking about $100 extra per week. Here you can make that in literally 1 shift, working a near minimum wage job. How about doing that instead of going to a court trying to leech off your ex-husband of 2 years? So far, this is so much of a joke that the ex-husband didn't even show up, which that alone speaks volumes. And lastly, if this woman is getting harassed, this isn't really the place to go. I'd probably contact the police station instead of the support court. But yeah, for someone who seems to really despise and hate her ex-husband so much that you want to get a restraining order against him, she seems to still be madly in love with that wallet.
I think I deserve that extra $100 a week, and he can certainly afford it.
What does he do for a living?
He's a CEO for an oil company.
Okay.
Makes really good money, bonuses and all that stuff. I mean, he's just raking it in.
How much is your spousal maintenance right now?
The spousal maintenance, it's about $325 a week maybe.
Okay. What type of expenses do you have?
Well, I have rent. I'm still making the payments on the house. And then, I got food. My car's paid off, but, gasoline's expensive, the upkeep of the car, things like that, electric bills, water, everything like that. Not to mention entertainment. I mean, can't expect me to sit around the house and watch TV all the time. I mean, I go out from time to time, that takes money.
Now, when you all were divorced 2 years ago, outside of spousal maintenance, were you awarded the home?
Yes, I was awarded the home. And he fought me on that, but I won it.
Okay. So you were awarded the home. You don't have a lot of payments left on it.
No.
So I guess I'm confused as to why you're here, because you haven't said anything that will warrant an increase in your maintenance.
Well, I went down on hours from work. I mean, that's a financial burden.
Well, okay, so you went down on hours.
My boss did. I didn't do it. My boss made me take less hours.
Again, what exactly does that have to do with getting more money from your ex-husband? If you get divorced, then you suddenly start making less cash for whatever reason. That's a you issue. Get a second job, start saving more money, spend less money. But don't go to court trying to get $100 a week extra. This is parasitic, bum, deadbeat behavior. The entitlement is off the charts here. And keep in mind, these two apparently have been divorced for 2 years now. 2 years is a pretty decent amount of time. I would think that a solid 2 years is more than enough time to sort yourself out and organize your life and finances in a way to be financially independent, instead of setting up court cases. If I had to decide, I'm not sure spousal support should even be a thing past 1 year, and that's pushing it. This entire case is so ridiculous that it's almost comedic at this point.
But nothing has really changed with a lot of your expenses. You said you don't have a car note. You have a little bit left on your home to pay off. Sounds like you're mainly paying utilities and then a mortgage.
And the insurance for the car, I mean, the insurance is always expensive. Gasoline prices always going up.
Right, but you had those expenses at the time that you were divorced, correct?
Yes.
When you all were divorced, did he have a 401k in existence? And this is Texas, which is a community property state, so I'm assuming you at least got 50% of that.
Yes, I did, but
yes,
I don't think that should be taken into consideration.
No, ma'am. It was taken into consideration the first time you received spousal maintenance. You can't have me take it into consideration again. That's not fair, and it's definitely not the law.
My age, I'm not going to find much now. I have to stay where I'm at. I feel like I'm trapped in this life.
And Ms. Ellison, I feel like you came here to waste my time, because I cannot give you an increase in spousal maintenance just because you're asking for it. No, ma'am.
25?
Even $5. The answer is no. So is there anything else that you needed from me here today? Because I cannot grant you spousal maintenance just because he's made an increase from his wages.
Well,
if that were the standard, then everyone would come in court asking for an increase.
Well, people need increases. I mean,
well,
women living on their own, I mean, that's hard.
Let me ask you this question. When you all were divorced and you received half of his 401k, how much was that?
It was a nice piece.
Okay, what's a nice piece? Give me a number.
About $250,000.
Okay, well, you know what? If there's nothing further, your case is dismissed, and so are you. Thank you.
Now, this is a curveball I don't think anybody saw coming. Let me get this straight. Not only did this person get the house, get her car paid off, is getting weekly spousal support, but also $250K on top of that. The audacity you got to have to show your face in court for spousal support, after getting $250K, I could have pretty much been this lady's retirement money. And the thing that confuses me the most is that she makes it sound like she's struggling financially. She's still paying off the house, the car insurance and whatnot. So my question is, where did the $250K go? Did it just vanish overnight? Is it spent? Because if that's the case, this woman somehow found a way to blow $250K in a matter of 2 years. I guess maybe she spent it on weekly trips to the hair salon, went on a coke binge perhaps. I don't know. What I do know is that this is one of the biggest jokes I've ever seen on this show so far. I'm speechless, and let me know what you guys think in the comments.
I mean, I can't even afford to get my nails done, my hair done. It's embarrassing.
Get ready to witness quite possibly the greediest Karen you've ever seen. So it's no secret that in this day and age, it's not uncommon at all to hear about athletes, celebrities, and even people you know in real life getting completely assaulted financially by the court system, unrightfully so. And today we're going to be taking a look at this mom who took her ex-husband to court in order to get some more of that sweet, juicy child support money. And as we're about to see, it backfires on her hard. And of course, this is another episode of one of my favorite shows out there, Support Court with Judge Vonda Bailey.
Okay, Mrs. Williams, you brought this case before the court. What's going on?
Yes, ma'am. We have 3 children together. I have not received any child support from him. Our children go to private school. They play sports, dance lessons, singing lessons. They're very active and it's very expensive. We do share custody and time, but I pay for private school. He pays for health insurance and that's all. I pay for everything else.
What kind of money you make to be paying all of that?
I'm an attorney.
Oh, okay.
But I'm used to a certain lifestyle. I mean, I can't even afford to get my nails done, my hair done. It's embarrassing.
You're an
attorney, yes,
and
ma'am.
you can afford tuition, but not to get your nails done.
Because all my money's going to the tuition and all of their extracurricular activities. I've been sacrificing the things that I'm used to that I was able to do before when we were still together and we had that combined income. And now all my money's going to the kids and I don't have any money left for the lifestyle that I've been accustomed to and getting my nails done and my hair and massages and things like that.
So far, this woman is actually being a relatively good mom, you know, paying for her kids' tuition and activities and whatnot, you know, which is great. I can't say anything bad about that. But what confuses me immediately is why exactly this woman decided to take her ex-husband to court. I mean, she is chasing child support money here. But as far as I can tell, it doesn't sound like she needs any help paying for things relating to the kids. It sounds like she needs help paying for her and her lifestyle, like getting her hair done, nails, massages, which isn't exactly what you'd consider child support. I mean, this just sounds more like an allowance. Like, what was the logic heading into the courtroom? I'm going to ask for extra child support, but then proceed to complain about how I can't get my hair done anymore. Well, yeah, you're a parent, and being a parent comes with making sacrifices financially. I mean, that's just common sense when it comes to having a kid, that you're going to lose out on some luxuries. Immediately, I get the impression that this woman walked into the court and thought this was going to be a slam dunk case for some extra cash. But let's see what happened.
All my money's going to the kids and I don't have any money left for the lifestyle that I've been accustomed to and getting my nails done and my hair and massages and things like that.
It's still not making sense to me. Mr. Williams, make this make sense.
You know, although she makes more money, she has an extravagant lifestyle. The hair, the nails, the massage. You know, she didn't tell you about the personal chef or the maid that she has come clean the house every week.
So now it's making sense, okay.
And let alone the drinking problem that you have.
Drinking problem?
The weekly stops to the liquor store to have a curbside pickup. Come on now.
He's telling the truth, isn't he?
Well, you know, after being in court
that wasn't
all day,
my question. He's telling the truth, isn't he?
I do like to have a cocktail now and then.
So the answer is yes?
Yes.
Okay. And you brought him to court?
Yes.
For child support?
Yes, ma'am.
How much money do you make?
$70,000 a year. I make $100,000 less than she does.
But again, I pay for pretty much everything. The only thing he pays for the kids is the health insurance.
Health insurance is pretty important. You'd agree with me, right?
It is, and I appreciate that. I do. But I don't want to pull my kids from private school or you know, take them out of the things that they love to do because I can't afford it.
Or you could just, you know, not hire a personal chef. You could stop drinking, and then maybe you could afford it. Maybe you wouldn't have to go to court to get more child support from somebody who's making $100,000 less than you. Also, I don't know why I keep saying child support, because from the sound of it, if she does end up getting more support, that money is never going to reach the children in any way, shape, or form, not in a million years. This woman's primary concern seems to be just getting her hair done, nails, makeup, and massages. I don't know how, as an attorney, she thought she could schedule this court hearing and think this would work in her favor. And I get that this mom is paying for more things, but the fact that the only reason she seems to be here in the first place is to get money to support a more luxurious lifestyle, it's just strange, let alone from someone who's making a lot less money than you. I don't know, it would be very different if you needed the extra support to actually take care of the kids and not for massages, liquor, and trips to the nail salon.
Don't say that again, because you can't afford it. You're getting your nails done, you're going on trips, you're doing all of these other things, especially going to the liquor store. Alcohol is not cheap. You can't afford it. You're just choosing to do something other than what you should be doing, which is taking care of these children. I'm assuming you don't live together anymore, right? How often are you all exchanging the children?
We have them equally, so that'll be 2 weekends a month.
All right, yeah. You came in here to waste my time. I am not going to make him pay you child support when you make $100,000 more than he does. What kind of lawyer are you? Never mind. So this is what we're going to do. I am going to do the child support calculations for the both of you and subtract it. And the difference is going to go to the person who makes more, which is you. So for mom, your gross is about $12,325.35. Dad, your gross is $5,833.33. Health insurance, you pay it, how much is it?
It's $100 a month.
Okay, you're gonna split that. So $50 for you, $50 for you. How many children? 2 children, right?
We have 3 children between us and 4 total.
3 children, 4 total. Who has the other child? Okay, thank you for telling me that, because that reduces your child support obligation and increases yours. So it comes out to $1,533 per month. And Mrs. Williams, that's what you're going to be ordered to pay to him. Any questions about that?
No, Your Honor.
Okay. Do you have any questions about anything I just said?
No, ma'am.
Okay. Well, if there's nothing further, you all are dismissed.
You know, for being an attorney, this woman is not the sharpest tool in the shed. $1,533 per month? Talk about a backfire. I guess when you're this greedy and entitled as a person, that's going to surpass any logic or critical thinking ability, even for someone who should already know basic laws relating to child support. Next, we head to Dallas, Texas for a civil hearing. 33-year-old Amanda Stiles and her ex-husband, Ryan Parnell, are in a child custody dispute. Parnell's attorney, Lacey Kimball, has filed several motions with the court, which include a request that Stiles take a drug test. Today, both parties appear remotely before Judge Drew Ten-Isa to review the motions. Stiles appears without an attorney.
Good morning. How are you all? Morning, how are you?
Morning.
Go ahead, Ms. Kimball.
A custody evaluation was completed, and so we have filed a motion for drug screening and a motion for psychological exam based upon that custody evaluation recommendations.
Blah, 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 blah.
Talking.
Things get off to a rocky start.
You'll be able to respond in just a second. Ms. Kimball, you can go ahead and finish, and then Ms. Stiles, you'll have an opportunity to respond in just a minute.
The judge remains calm as Kimball continues.
We also had sent discovery out as laid out in our motion sometime back. We ultimately never got a response.
We got responses. Objection.
Hold on, wait a second. Ms. Stiles, you just need to object, and then let me know what your objection is. Don't yell at her.
Object to hearsay.
Hold on.
Judge Tenack presses the mute button on Stiles, allowing Kimball to speak without interruption.
And then we have an order to compel Ms. Stiles to provide dates for a deposition.
All right, so Ms. Stiles, I'm sending you a prompt to unmute. If you just unmute yourself, you can respond.
Despite her disruptive behavior, the judge moves forward, attempting to get Stiles' responses to the 4 motions in question.
Do you have an objection to taking a drug test?
I use marijuana daily. All day, every day. So I'm glad to take the drug test.
Stop.
It's going to be on his expense, but
Stop. I'm pretty low key. We're in court. You need to be respectful. Just say Judge Tenack. Okay, it's pretty easy. So you use marijuana all day, every day?
Not really all day, every day, but I use it daily, if that helps you with your interpretations. Mr. Low-Key Honorable Judge Tenack.
I'm not interpreting. I just said what you said. What is your response to the request for a psychological evaluation?
I'm not doing it, and you cannot force me to do it. You cannot physically make me go and show up and partake in anything that I do not want to partake in. Yes or no? Do you agree or not agree?
You don't get to ask me questions right now. What's your response to their motion to compel?
Have you read their discovery?
Ma'am, you need to answer my question.
I answered your question.
All right.
By now, even this low-key judge seems to be losing patience.
So I'm going to warn you that it is completely inappropriate to swear like that in court.
Stiles then pushes her camera away.
You need to take yourself, you need to put yourself back on camera. I'm gonna sanction you $100 for every time that you swear in court, because that's not appropriate. You just need to not do it.
Judge Ten Eyck tries to get back on track.
In terms of the deposition dates, what's your response to that?
What dates?
Ms. Kimball, do you have proposed dates?
And whose expense? Mine? Because if it's mine, I'm not doing it. Sanction, give me $100 fee. Woo woo.
So I am finding you in direct contempt.
Okay, one fine.
Finding you $100.
Okay, make it 2. Damn. I said 2 words.
Ma'am, I don't think you want to do this. I will, as I said, sanction you.
Please do.
Before ending the hearing, the judge tries to get a deposition date on the books.
Which of those dates works better for you, Ms. Stiles?
What time? Dumb. 3 contempt.
Correct, that is 3.
Supposed to start at 9 a.m.
What date?
That question is to you. Never
I
mind.
said what
Not-
time?
not gonna let
Time,
you-
date? You know, these
not
things.
gonna let you look. You don't get to do this for your own pocketbook. I'm muting you for. All right, I'm going to count that as another violation.
Stiles was held in contempt and ordered to pay $400 in fines. As for the child custody case, Stiles later relinquished her rights to the child, including any visitation rights, and the father, Ryan Parnell, has full custody.
This is clearly the most shocking news we've ever gotten in this courtroom.
For 20 years, this Karen told this man he was the father of her son.
You say you have proof that Mr. Manser is Dylan's father to finally stop him running from his responsibility.
Yes, ma'am.
This is Elizabeth Sear of Southwest Missouri. She told Bill Manser he was the father to her child.
I didn't find out anything about the child until I was served with papers in 1995.
Neither Manser nor Sear disputes that in Southwest Missouri in 1992, they had some kind of sexual relationship.
But as far as intimacy, we was together one time, and I hate to be crude, but it was a one-night stand.
I don't care what your version was. I was far from a one-night stand.
Living across the street from each other?
Far from a one-night stand.
Regardless, she gave birth to a son, Dylan, in January 1993. A couple years later, Sarah ordered a paternity test. The test concluded that there was a 99.6% probability that Manser had fathered the boy. Manser moved to Lake County, Florida, and he was named the father because he missed a court date.
And so you showed up for court, and what
no,
happened?
I wasn't able to show up for court. I was completely on the other side of the state. I was indigent. I was living at my mom's, didn't have a job at the time. So I didn't show up for court, and I was named the natural father by default.
And then what happened?
He ended up paying more than $30,000 in child support to Sear and spent 5 years in prison after failing to pay on time.
And then when I went to prison for 5 years, when I got out of prison in 2003, I paid child support from that day until just February of last year when I lost my job.
Only because they garnished your wages.
Absolutely, that's what they do. And I actually asked my public defender, where's the proof? I've yet to see proof that the child's mine. He said that they obtained my DNA through a sample that was already on file. That's what she's claimed this whole time.
For a daughter you didn't raise too.
So, that's right. I'm not here to win any Father of the Year awards, believe me.
You wouldn't get it.
So, but I'm here to say that You know, in today's society, I think it's cruel and unusual punishment to be sentenced to 5 years in prison with rapists and murderers and child molesters for missing a court date. Because that's basically what happened. I missed a court date.
You missed being a father.
Sarah herself had good reason to believe the narrative. A paternity test she'd ordered from a lab concluded with near certainty that Manser was her baby daddy.
We do, however, see a lab record of a collection taken on May the 1st, 1995, which they claim was you. Ms. Sear, I see the laboratory results of the testing with a probability of paternity of 99.67%.
But he was never totally convinced Dylan was his son.
Do you know, man, that he said 99.67 means he still might not be the father when he heard that number?
On August 12th, 2013, Manser Elizabeth Sir and her 20-year-old son, Dylan, submitted to new DNA tests at a California lab frequently used by the paternity court show. They appeared on the show on August 29th and got a rather different result.
I think it's time for the results.
Yes, ma'am.
All right. Jerome, lab, because of the sensitivity of this issue, ran 2 tests. The results are as follows. In the case of Manser versus Sear, as it pertains to 20-year-old Dylan Sear, Mr. Manser, you are not
God.
his father.
Oh, man. 5 years in prison.
This is clearly the most shocking news we've ever gotten in this courtroom.
But the most shocking moment is yet to come. Listen to what this Karen is about to say.
Do you want to find out who your father is?
Of course.
Miss Sear, you know who his father is.
Yes, I talk to him still. Yes, I talk to him still.
You cannot stand there and really suggest that you cannot comprehend why this man would not have any type of ill feeling, frustration, or regret as it relates to anything involving you. 5 years in prison. And then I say, do you know who your son's father is? And you say, yes, I'm still in touch with him. That is a really huge pill to swallow.
That's 200 days. You got anything else to say, Miss Burks? No. That's 300 days.
Next, we go to a bond hearing in Elyria, Ohio. Appearing remotely is the defendant, Ebony Burks. She's charged with misdemeanor assault and domestic violence against her grandfather, Shedrick McRae, and his companion. At the bench is Judge Gary Bennett.
Good morning, Miss Burks.
Good morning.
After reading the charges, the judge asked Burks how she'd like to plea.
You have 3 pleas available to you today. Guilty, not guilty, and no contest. What plea would you enter?
I'm not guilty.
So far, so good. The judge sets bond for the 2 charges at $15,000. His only condition is that Burks not be in contact with the victims, which could be difficult since she shares a home with McRae.
No contact means you can't call him, you can't write him, you can't text him, you can't email him, can't leave a message on some social media, you can't go visit him. If you go someplace, even though you may have arrived first and one of them shows up, you have to leave.
So you gonna tell me I can't go home?
I'm telling you, you can't go home. If you live with Mr. McRae, you cannot return to that residence.
Oh, but how you just gonna tell me I can't go home?
What?
How you gonna tell me I can't go to my home?
I just did.
Typically, right about now, a lawyer or even a judge might try to de-escalate the situation. But it's clear this is not a typical bond hearing.
How you gonna tell me I can't go to my home?
I just did.
Well, I bet I do.
Well, then you're in contempt, young lady, and you got 30 days. So you're not going. You're not what?
Whoa, whoa, whoa.
Get back! Get back!
Get
back! That's another 30 days. That's 60 days.
So what?
90 days.
So?
120 days.
Okay, and?
180 days.
Oh! Get off me!
It looks like Burks may be finished.
What else you got to say?
Hold on, she's coming back.
Nothing. We'll talk in 6 months when you're ready to come back for your case.
I ain't got money.
That's 200 days. You got anything else to say, Miss Burks? That's 300 days.
Though she racked up 300 days, Burks only ended up serving 88. According to Judge Bennett, it was the longest sentence he's ever imposed for contempt of court. As for her assault and domestic violence charges, they were suspended, but she was forced to enter a substance abuse program.
Sorry, Your Honor. Not as sorry as she's gonna be.
This is Taylor Shaw business. She appeared before a judge for a competency hearing to assess whether she could understand the court proceedings and assist in her defense. In February of 2022, 25-year-old Taylor Shea Business was involved in a case that seemed ripped from a horror novel. Taylor and her lover, 24-year-old Shad Therian, were together one night when their usual routine took a dark turn. After smoking meth, Taylor, in a fit of drug-induced rage, strangled Shad to death with a chain in the basement of his mother's house. However, the horror did not end there. In the hours that followed, authorities claimed that Taylor Shea Business sexually abused Shad's lifeless body before proceeding to dismember him. Panicked and in shock, Shub Business immediately contacted the authorities. Shub Business was charged with first-degree intentional homicide, mutilating a corpse, and third-degree sexual assault. During the competency hearing, Judge Thomas Walsh presided, while attorney Quinn Jolly represented Shaw Business. An expert hired by the defense was expected to testify in the coming days, but Jolly stated that the doctor needed more time to complete his report.
Our doctor is requesting 2 additional weeks to finish preparation and evaluation of report.
Judge Walsh granted the motion, pushing back the start date of the trial to allow for a comprehensive assessment.
During the trial, and we're looking at the week of May 15th for the trial.
And in that moment, Shub Business jumped out of her chair and lunged at her attorney in a fit of uncontrolled anger. Watch it from this angle. The court officers sprang into action and restrained her. The deputies were able to remove her and place her in a holding cell. Once order was restored and the hearing reconvened, Jolly, who had remarkably sustained no injuries during the attack, requested to withdraw as Shaw Business's attorney.
At this point, I'm going to put a motion in to withdraw from this matter.
Judge Walsh granted Jolly's motion to withdraw, and Shaw Business was assigned a new attorney from the State Public Defender Office. Notably, she faced no additional charges for the attack on Jolly. Taylor Shaw Business was sentenced to life in prison without parole for killing and dismembering her boyfriend. Next, we go to a bond hearing in Miami-Dade County, where the presiding judge is Gerald Klein. As he addresses the defendant, keep your eyes on the woman in the background, 24-year-old Nicole Babb. Babb's impromptu striptease gets some chuckles from just about everyone in the courtroom. Everyone, that is, except for the judge. The 84-year-old Klein, whose nickname is Fast Jerry because he moved through cases so quickly, appears unfazed by Babb's performance. Take another look. As Babb disrobes and takes her act to the floor, it's clear it'll take a little more than some full-on nudity to distract Judge Klein. Looks like after 40 years on the bench, Judge Klein has seen it all. Not even a round of applause from the spectators can distract him from the case at hand. After things calm down, Judge Klein is ready for the next defendant, who, of course, is
Judge, that was a stripper.
She's still in court. I can bring her up and hold the garment. CJ, we'll hold the garment.
She's still here?
I got her right.
Judge?
Yes.
They said they can bring her up and they'll hold the garment on her this time.
The situation finally gets a smile out of the judge.
No, she's here, Judge.
She's here.
Yes, they're just gonna hold the Ferguson garment on her.
She's coming.
A newly clothed Bab, charged with identity theft, approaches the podium.
What's her status in the other matter?
5,000.
Ma'am, are you homeless?
The defendant doesn't stick around to answer.
Not.
He's talking to you. He's talking to you.
No, I'm not. I don't want to stay here. No.
Miss Beth.
She doesn't want to stay, Judge. She wants to leave.
You're charged with criminal use of personal identity.
And with that, Judge Klein sets the bond, $5,000.